Vidyabharti sir,
हाँ sir.
Sandesh and Bhavna Singh is going to join with us now. Okay.
Okay sir.
The guests are available with us.
Okay sir.
सर युट्यूबला दिसत आहे.
हाँ स्लाइड आलेली आहे ना.
हा ओके सर.
Yeah, it's fine. Yeah sir.
Okay. Good morning, Sandesh sir.
Okay sir.
Ashankar.
Davande sir. Yes, it is streaming on YouTube.
That's fine.
Yeah. Singh madam. Agrawal sir.
Hello.
Please unmute, ma'am. Please.
Hello.
Hello. Good morning, madam.
Good morning, sir.
Good morning. Singh madam.
Yes, sir.
Please share your PPT.
Sure. Just give me a moment, please.
Yeah. Sasankar sir. Yeah, it's fine, ma'am.
Yeah, it is fine.
It's fine. Okay.
Is it visible to everybody?
Yeah.
Visible.
Please move 1 or 2 slide, ma'am.
Okay.
Yes. Just to check it.
Oh, 1 minute.
Yeah. It's working, ma'am.
All right.
Okay. Agrawal sir.
Hello, sir.
Please, madam, please stop your sharing, ma'am.
All right.
So
sir.
Agrawal sir, share the slide. So within a couple of minutes, we will start our program.
Shall I stop sharing?
Yeah.
Okay.
Sir, we have the same slide, sir. So this is the testing is done, sir. According.
Okay.
Ha.
So then no issue. No issue, sir.
Yes, sir. No issue at all. Sir.
Okay.
Sir, how many are going to join? Any idea? Rough?
Just within 5 minutes, we can start that, sir.
Yes, sir. I will allow the participant all 20 waiting room. So Sanskar, shall I admit all this to participants?
Yeah, okay, go ahead.
Yeah, okay, sir.
Yes, with the chair, shall we start the program, sir?
Yeah, go ahead.
Yes. A very good morning to all the participants today who joined this wonderful workshop on understanding intellectual property. First of all, I welcome on the behalf of Mahila Vikas Sanstha and Vidyabharti Sanstha and all the respected 3 principal of Arts and Science College Pulgaon, Vidyabharti College seloo, and New Arts, Commerce and Science College Wardha. So with this today's 2 eminent person Sandesh Agrawal sir, the manager, and along with the Bhavna Singh, who delivered the technical session. So to start this technical session, now I requested the honorable, the dynamic principal, Dr. Sasankar sir, to say a few words on this movement. Over to Sasankar sir.
Thank you. Thank you very much. Respected dignitaries present for today's webinar on intellectual property rights. Our beloved chairman, sir, Dr. R.G. Bhair, sir, our secretary, Dr. Abhijit Verurkar, sir, Principal Dr. Hardge, sir, from Arts and Science College, Pulgaon, Principal Dr. Sanjay Kanode, sir, Vidyabharti College, Seloo, and I, Dr. Ashish Sasankar, Principal, New Arts Commerce Science College, Wardha. On behalf of our organizing team, I welcome our guest speaker, Mr. Sandesh Agrawal, Manager of IPCurate Lab, Ms. Bhavna Singh, Technical Expert from IPCurate Lab, and Param Doshi, sir. I also welcome all delegates, faculties, and participants present for this workshop. Nowadays, IP is playing very much important role in research and faculty life. But it is unfortunate that only 5 to 10% researchers are trying to work on IP. This is not because of they don't have knowledge, they have the good knowledge, but they have lack of information of how to implement IP on their research work. In the modern world, intellectual property rights have the significant influence on international trades and indigenous trades of every nation. With the advent of digitization, there are high chances of creative ideas being stolen by any third party without any prior permission. Intellectual property rights have added the intrinsic value to the all kinds of products as a unique creation, and ideas are becoming a more and more important aspect of any business or any research. Nowadays, illegal use of these unique ideas generated by other person has become one of the most common crime these days. However, there are many businesses which still fail to realize the IP value and risk associated with it, even when an IP asset rack on for the high percentage of company's value. Thus, not taking any punitive measures for IP protection could be detrimental to the overall growth of the business. Hence, it can be concluded that IP protection is indispensable and all the countries must have distressing laws for protecting intellectual property rights. So it is high time for all nations to duly recognize the IP rights of their native and individual organization. I hope that you will enjoy this workshop and try to implement tips and tricks which will be shared by our today's expert. Lastly, I want to thank once again Mr. Param Doshi sir from IPCurate Lab for arranging speaker for this workshop. Thank you. Over to you. Thank you.
Thank you, sir, for your valuable words. Now I requested a Pethare sir to give a brief introduction of today's resource person, Bhavna Singh. Madam, over to
Hello.
Pathare sir.
Okay. On the behalf of New Arts, Commerce and Science College, Wardha, I welcome all the delegates, all the speakers, and all the students who get participated in the one-day online workshop on understanding intellectual properties. So it offered me an immense pleasure to introduce the today's guest, Honorable Bhavna Singh Madam. Initially, she had graduation in biotechnology. After she had an enlightening career, delving from research for initial few years, then she posted her research of interest to protecting the inventions legally through intellectual properties. So with more than 100 projects she had completed under her belt, she is the technical person, technical expert in all the matters. So it will be the nice experience to hear the expertise of Honorable Bhavna Singh, madam. So over to Bhavna Singh, madam, please.
Thank you, sir. Thank you so much for this wonderful introduction. Let's start with the session now. Um, I'll be sharing my slide with everybody. Am I audible? Hello?
Yes, madam. Yeah.
Okay, just
Yes,
give me a
madam.
moment. I'll be sharing the slides. Param, am I restricted for sharing the slides? I am unable to share my slides.
Yogesh sir, could you please look
Yeah.
at?
Yes, sir.
सेटिंग मध्ये जाऊन ऑल पॅनलिस्ट करा.
Yeah.
Sir, just now we tried before the allowing participants.
Yeah.
Is it visible right now?
Yeah, it just
Yes.
being
Yes,
shown.
yes, madam.
Yes,
All
madam.
right. All right. Let's start. Okay, good morning, everyone. I'm Bhavna. I've pursued my MTech with specialization in genetic engineering from Gautam Buddha University. And currently, I'm working with Verispire Technologies Private Limited. I'll be taking this session, Understanding Intellectual Property Rights, with my colleague, Mr. Sandesh Agarwal and Mr. Param Doshi. The session will be of 1 hour, 15 minutes roughly. And soon after that, we'll be taking your queries. In case you have any query during the lecture, please park your questions in the comment section and we'll try to answer them as soon as possible. So let's start with the session. Now, we'll be covering few basic concepts of intellectual property. The basic purpose of this session is to familiarize the students, the scholars, as well as the faculty members with the concept of intellectual property and the various rights which are associated with it. In this one-day workshop, we'll be discussing about intellectual property rights and its various types. We'll also discuss about the merits and demerits of the intellectual property and not protecting your property, and how it helps any organization or a startup to grow and generate revenue. In addition to this, we'll be studying some lawsuits which are related to intellectual property. So let's start with the session. Now, the first thing we will discuss is what is intellectual property. Now, intellectual property, this complete word comprises of two words. One is intellect, which means human mind or creativity or property. And the other word is property, which means real or any intangible good that has a rightful owner. When we combine these two words, we get intellectual property. Now, intellectual property is basically a creation of human mind. Now, this creation could be in any tangible form. That means it can be touched. Like, for example, it can be any product, like a phone or a car or a camera itself. And it could be any intangible product as well, like song lyrics or a trade name, from a needle to an aeroplane. Anything that is created by a human effort is an intellectual property. Now, the noticeable difference between both the forms of property is that you cannot measure intellectual property with the help of parameters. Like, you cannot say, I have 10 cameras, so that means I have 10 intellectual property. The intellectual property will be your camera, it will be counted as one. Now, the intellectual property rights are the rights which are given to a person over the creation of human mind. Let's say I have a product, I have an invention. The rights, the ownership, or the position which I have over that invention is IP rights, is actually intellectual property rights. Now, these rights are usually exclusive in nature. That means I have a right on my own invention for a defined period of time. These rights are majorly legal in nature. That means if someone tries to use my creation without my consent or without the consent of the owner, a lawsuit can be filed against that person. These rights are not just for the invention but also for manufacturing. That means nobody, no other person or an individual can manufacture or sell or even license the property without my or the owner's consent. Now, these IP rights have various categories. Here we can say that one size does not fit all. Every invention or every creation is different in many aspects. So we need different types of rights. We need different nature of right for the protection. The intellectual property rights are categorized into four broad categories. We can see that the first category is industrial property. The second is copyrights and other related rights. Third is protection of plant varieties. And the fourth one is traditional knowledge. Now, this industrial property, it is further categorized into or divided into 6 subtypes, which are patent, trademarks, industrial designs, layout of an integrated circuit, geographical indications, and trade secrets. We will discuss all these types in the coming slide. Now, the first intellectual property that we will discuss here is a patent. Now, what is a patent? A patent is a form of exclusive IP right. This right provides the owner with a legal right to exclude others from making, using, or selling an invention for a limited period of years. That means, let's say a person has an invention, so that person can exclude other people or has a right or has a privilege that is granted by the government to exclude other people from making, using, or even importing that invention. Now, this right is in exchange for publishing the invention and enabling public disclosure of the invention. Now, these rights fall under the law. That means the patent holder, the patentee, or the patent holder has a right to sue someone who is using or manufacturing their invention without their consent. That means these rights fall under the legal category as well. Now, the third thing is the patent protection lasts for about 20 years. Now, when a person is granted a patent, that protection lasts for 20 years. Now, this means the person has a right over their invention for 20 years. For 20 years, if any other entity or any other individual wants to use that invention, they have to take a permission from that person. The rights, the patent rights are basically territorial in nature. That means the patent is valid in the country in which it is granted. Let's say I want to protect my invention. Let's say I have a pen and that pen can write underwater. Now I want to protect that invention in India as well as in US. Now I cannot do this thing that I could apply for a worldwide patent. I have to apply in India separately and I have to apply in US separately to get patent protection in both the territory. That means patent rights, generally all the IP rights are territorial in nature and patents are also territorial in nature. Now, rights of a patentee. Now, the person who has a patent protection, like I have a patent grant over an invention. Let's say I made a pen that could write underwater. Now I have a patent protection for that creation. Now I am known as patentee. I have a patent. Okay. Now the patentee enjoys a legal monopoly over their intellectual property. Now I have rights. I have exclusive rights to exploit my invention. I have rights to use my invention. I have rights to assign and license that invention. That means the patentee is entitled to possess, use, or have any benefit from that invention. No other entity or an individual without the authorization of patentee can use that invention. Now, the main term, the exploitation of patent, refers to selling the invention as well as making the invention, as well as the other person cannot even offer to sell or import the patented product. Now, any individual cannot even directly or indirectly use the product. Let's say I have a process in which compound A is generated. Now, any other person cannot, just because I have a patent on the process, the other person cannot even use the product because that product is directly linked to my patent. Now, any individual cannot even directly or indirectly use the product which are directly obtained from the patented product. For example, you made a pen and I want to use that pen. I would have to take your consent for using that pen, for making that pen, and even for selling your pen. Now, the patentee also has a right of assignment. That means the complete patent, or in fact, a part of that patent can be assigned to any other person by the patentee. But any individual exploiting the patent without a written licensing contract has to pay a fee for exploitation. That means if I'm exploiting someone's patent who doesn't who has not given me a proper license, that means I am obliged to pay that person for an infringement suit. Now, in addition to that, the patentee can also have a right to use the, or I should say, the patentee has a right to mark their product or indicate a patent number. Let's say I have a patent on a coffee mug. Now I can put a patent number on the packaging or on the product itself. Apart from these main rights, the patentee also enjoys some basic rights. Let's say the patentee has a right to apply in other countries for the protection. In case of infringement, they have a right to sue that person. The most interesting part of a patent is the patentee can also apply for a patent of addition. Like the name suggests, patent of addition. Let's say I have a product X for which I have filed a patent. Now, somehow, or with my intellect, I made a modification or I made an improvement of that product. Let's take an example of phone. Earlier, there was 2.0 VGA cameras. Now I have made 64 megapixel camera. Okay, it is an improvement of the same product. Okay, so I can apply for a patent of addition. I can add that modification in the existing patent as well. So there are certain basic rights that a patentee enjoys, like exploitation, assigning a license, to apply for an addition, to apply in other countries as well. Now, patents are not granted simply to the invention. Patents are granted for any invention in all areas of technology, be it biotechnology, be it computer science, be it mechanical or electronics, or any other general invention which solves the problem or which is new or in any area of technology. Now, there are certain requirements that is to be filled or that is to be fulfilled by the invention. Now, what are these requirements? There's a very famous quotation that says everything under the sun made by man can be patented. And I personally find this quotation very appropriate in terms of patent. Anything that is under the sun and is made by man can be patented if it's new, if it's novel, if it's solving a problem. Now, these inventions can be the inventions which are patented or which are granted patent, can be in any terms, can be in the form of process or a method. Like I have I have skills by which I can extract an enzyme. I have a process, I have developed a process by which I can extract an enzyme from neem tree. Now that process takes less amount of time as compared to other process, as compared to other existing process. Now that process can be patented. Now I have a machine. I have a machine by which I use that process to extract enzymes from neem tree. Now that machine or the complete device can be patented. I have a manufacturing method. Let's say I can artificially synthesize an enzyme or a metabolite that is from a neem. Now that manufacturing method, the complete method can also be patented. Any composition of matter, anything new or useful improvement, anything new which does not exist already in nature can be patented. Now there are three basic conditions that need to be satisfied for the grant of patent. Now these conditions are called as patentability requirements. The first condition is the invention should be novel in nature. This means that the invention must not be made public, not even by yourself, before the date of application. This means new or novelty is the main criteria of patentability. Let's say I have developed a phone. Let's say I have developed a phone that could zoom to an extent that I could capture pictures of moon. Okay, a bit hypothetical, but let's take this example. Okay, now I have published a pamphlet, or I have published that invention in newspaper. Okay, this would be considered as already existing invention because I myself made that invention public. So you, this criteria is very important. We do not have to disclose our inventions to anybody before protecting it, before patenting it. Okay, anything that is published in a magazine or in a symposium or in a conference is would be termed as a prior art. So novelty is very important in terms of patent. Now the second criteria is inventive step. This means that your product or your process must have an inventive solution. It cannot be a solution that is obvious to a manufacturer. Let's say I'm a biotechnologist. I know if I'll add a plasmid from a bacteria that could eat up, let's say, plastics, that could eat up plastic. So I took the plasmid and I have put that plasmid in some other stuff. No, that is already obvious to me. If I'll do this, this would be the end result. It should be different. The main question here is whether the person skilled in the same subject matter would be able to decipher it or not. If that person is able to decipher it, if the person skilled in the subject matter is able to decipher the invention without making any efforts, it is not inventive. Okay. Now the third criteria is industrial applicability. This means the criteria implies it should be actually be able to manufacture. Uh, you cannot fumble an invention. You cannot say that I could make an invention work like this. You have to it should be applicable somewhere. In other words, you can only apply for a patent on a new kind of playing card. Let's say I have made a new kind of playing cards which are easier to hold. Let's say I have made a new kind of playing cards which are easily, which are smaller in size. Okay, uh, I just have this idea. I cannot protect the whole game. I can just protect that invention. Okay. So industrial applicability is also important. So we have learned three basic criteria of patentability, which are new, that is novelty, that the things already existing in nature or the things which are already mentioned somewhere are not considered new, are not novel. The second one is inventiveness. That means the person able or the person skilled in the subject matter should not be able to decipher the invention easily And the third one is industrial application. That means it must be possible to actually manufacture the new invention. It should not be just a plan or just an idea. Okay, so moving on to the next slide. Now, these are certain inventions which I find as very innovative, very up to the date. I'll let you decide ki whether these inventions are innovative. Actually, there are patents for these inventions. So I'll let you decide whether these are weird or innovative with regards to our time. Now, the first invention is a bench that dries surface is wet and we cannot sit anywhere. So this bench has a rotatory handle by its side, and you can rotate it and put the dry side on the upward position. So very unique solution to a problem, very common problem and very unique solution. Now the second invention, the invention B, is actually a toothpaste squeezer. You have to roll the squeezer and the toothpaste could come out. Now how innovative that person might be who had suggested a simple solution, a very simple solution for a very common problem. C is an umbrella with a cup holder. D is a keychain, a Lego keychain. You also might have encountered, I especially encountered this problem a lot, that I lose my keys everywhere all the time. So you can stick your keys to a specific chain, to a Lego. Now, E is an extension cord with removable sockets. You can actually add more sockets to it. You can actually remove the sockets from it. And it's an extension cord. You can take it anywhere. Now, F is a scooter with a baby crib. Now, you need something to travel. You can travel on the scooter as well as you can take your baby with you. You don't have to carry an extra crib for that. You don't have to carry an extra vehicle for that. A simple solution. Okay, now all these inventions might seem very simple, might seem very weird, but all these inventions have an industrial application. They are new. They have a solution for an example. Now, let's start with procedure to register a patent. Now, the first step to register a patent is filing of a patent application. Now, before filing the patent application, the applicant or the person who is going to apply needs to check whether the invention is patentable or not. Now, checking the invention is done by three criteria. We have already discussed: novelty, uh, inventiveness, and industrial application. Now, the application can be applied by the nation of any country. That means if I'm staying in India, I can apply for a patent in US as well if I want to protect my invention there. Now, any inventor or a person that an inventor has assigned or any legal representative of an inventor can apply for a patent grant. Now, the application needs to be submitted with several other forms, and I am not going to confuse everybody with those forms here. So let's move to second step, publication of application. Now, when a person has applied for a patent grant, the patent application is then published in an official patent journal after 18 months. Matlab, that means if I had applied for a patent application on let's say I have filed a patent application today. Now, after 18 months from today, the application will be published. Now, it can be published earlier also if the applicant makes a request. The application, if not published, the applications are sometimes not published if the applicant has given some secrecy directions. Let's say you are working on a government project. Let's say you are working on a defense project. That means you want your patent to be a secret. Now, generally, DRDO mainly files for these secrecy patents, the patents which they do not want to be published in an official gadgets. Now, the application also is not published if it is withdrawn within 3 months before the publication. Let's say you have already withdrawn your application within 15 months. Okay, before the after filing, then your application will not be published. Now, the rights of an applicant, the right of a patentee starts from the day of publication. They do not start by filing of patent, but they do start after the publication. However, these rights, you cannot enforce these rights for the grant of patent. Nobody can force these rights ki just because I have filed a patent application, I should get a grant of patent. Filing and publication are just first steps, are just initial steps of a grant of patent. Once the application is published, another person can also file an opposition. Now, next step is examination or examination of application. Now, this step, this process starts with request of examination. Now, this request of examination has to be made within 48 months of filing. Let's say I have put an application today. I have filed an application today. Now that application is published within 8 months, within 18 months of filing, and from that date of filing, from 48 months from that date of filing, my application would be examined. Now, what is examined in that application? Basically, the criterias of patentability are being fulfilled by the invention or not. This thing is actually examined by during the examination. Let's say my invention is already existing. Somebody has already patent on that. So I would not be getting that patent. So now these all things, whether the uh, invention has an industrial application or it is new, all these things are examined. In the cases where secrecy directions are issued, the examination can be made within 6 months. Now, after the examination, a first examination report is submitted that actually contains all the criteria: novelty, whether the invention is novel or not, whether it has inventive step or not, whether it is industrially applicable or not. Now, after the examination, opposition of patent application can be made. A patent application can be opposed by pre-grant. Pre-grant means before the grant of patent, and post-grant opposition. Okay, now post-grant means after the grant of patent, and pre-grant means before the grant of patent. In both ways, any person or any third party which thinks that patent should not have been granted here can oppose that invention. The opposition board or the board may invalidate the patent after the grant if the opposition stands like the patent should not be granted, and may even ask for amendments. Let's say I have made a product X, and someone a third party says that X should not be patented because I already hold a patent for that. No, in that case, amendments cannot be made. Let's say someone says X cannot be patented because it does not have novelty or it does not have inventive step. So I can change my invention. I can amend my invention accordingly, according to the mentioned criteria, so that it can get a patent. Now the final step is granting of patent. If the application satisfy all the requirements mandated by the Patent Act, that means the patent is new, that means the patent is inventive, it has an industrial application, a patent is granted. The granted patent is given a filing date, and then it is officially published in a gadget. Now the invention is open for public inspection, and the patent is granted for 20 years from the date of filing. Let's say I have filed a patent today. Now that patent has already reached to the granting step. Now the patent has been granted. From the filing till 20 years, I have my invention protected. Okay. Nobody can infringe that invention. And moreover, if somebody wants to use that invention, they'll be asking for a permission. Now, there's no such patent which is worldwide. If you have to protect your invention in multiple territories, you would have to file multiple applications. There's no patent that covers every country in the world. The patent system is territorial in nature. We have already discussed that. So in order to protect an invention worldwide, patent application is filed in respective countries. Now, Patent Cooperation Treaty provides a single filing system for all the member nations. Now, PCT provides a common procedure for filing a patent application to protect the invention in each of the contracting states. Now, there could be multiple contracting members, like India could be a member, China could be a member, US could be a member, and as an inventor or as a creator, as a researcher, I could apply for multiple countries or multiple territories for the grant of patent. Now, let's say I have an invention and I am an Indian national. Now I want to protect that invention in US as well, and I want to protect that invention in China as well. I'll be filing an invention. I'll be filing an application in my own country that would be protected. Then I can go ahead. Then I can have a PCT application forwarded. Now this PCT application will reach the designated offices. Let's say I want to protect it in US. Let's say I want to protect it in China. Let's say I want to protect it in Korea as well. Okay. Now my application will reach to 3 different countries, offices of 3 different regions, or offices of 3 different territories. Now these 3 different offices or these 3 different regions will decide whether they want to grant me a patent or not, depending upon the law of their country. Okay, let's say I want to protect an invention. I have made a phone. That phone can zoom out to an extent that I could take a picture, very clear picture of moon. Okay, I could even see that bunny which tells the direction, and I could take a very clear picture. Now, US and China the law allows me to protect that patent. So I'll get a grant of patent in those countries. But let's say Korea doesn't allow the grant of patent. So the application might be rejected by that particular region. Okay. Okay. A PCT application, if a person is applying for a PCT application, that does not means issuance of patent. That basically means ki I can communicate. I can send my application to the designated offices. All right. Okay. Now, there are 2 phases of PCT application. One is national phase, or which is also called as regional phase, and the second one is international phase. When international filing is done, it's called as when in which patent grant is generally pending, or it is being examined by the other countries or other regions. It is an international phase. And when it is applied in our own nation, then it is national phase or regional phase. Now, patent infringement cases. Now, there are instances, let's say technology is growing to the ends. Technology is growing right now at a very faster pace. So what happens is sometimes we don't know that we are infringing somebody else's right, and we sometimes use their patented product. Protected patent. Now this sometimes is mostly unknowingly, but sometimes it's done intentionally. So there are 3 cases, and I'll be discussing 2 of them. One is Apple versus Samsung Electronics. The second one is Diamond versus Chakravarti, which is a very famous case, and it changed the phase of patent. It changed the complete phase of patent. And the other one is Syngenta's pepper patent. Let's discuss Apple versus Samsung. Now, the patent battle between Apple and Samsung started in 2011. Now, it resulted in $1 billion ruling in the favor of Apple. Apple got $1 billion from Samsung because it lost the case. But the battle didn't end here. It was a series of appeals that was pushed to Supreme Court back and forth, and both the companies, both Samsung and Apple, were infringing each other's patent. Apple was infringing Samsung's patent and Samsung was infringing Apple's patent for different products. Okay. So now both the companies, a series of appeals were filed and the disputes were pushed to the court, and later it was found that Samsung owes Apple because of the infringement. The case revolved around a number of design and utility patents. Now let's say Apple has a feature in which if you'll pinch it, it will zoom. Okay, the screen itself, if you'll pinch it, if you'll make this pinching gesture on the screen, that means the screen will zoom. Now Samsung product, Samsung Galaxy had a same feature or a same setup in which if you pinch the screen, it will zoom. This pinch and zoom was already, this feature was already patented by Apple. However, Samsung knowingly or unknowingly used that in their Galaxy phones. Now in US, the cases were filed in two countries, US and Korea. There were many utility patents for basic functions of smartphone. Like there was a patent case for infringing the user interface of Apple, which was used by Samsung. Like you can see in the slide that everything, that every user calendar or gallery is in a square shape. Same user interface were used by Apple as well as Samsung. So there was one case regarding that. Now the verdict has whittled down to $539 million for Apple. Samsung had to pay $539 million to Apple for infringing. Now Samsung filed an appeal that earlier Apple was also infringing their patents, like the curved screen and everything, but the two companies were able to reach an agreement before the litigation. So according to the court, Apple won about $120 million over the violation of its slide to unlock patent and pinch to zoom patent. The two companies had their patent fight going on internationally, but both the companies agreed to drop their lawsuits back in 2014. So the thing is, if you talk about big companies, if you talk about giant tech companies, we are not talking about ones, hundreds or thousand rupees. We are talking about billions of dollars here. So patent infringement is such a serious issue that companies take each other to drag each other to courts for infringing their product, for confusing the customer that it's their product. So in short, if I say, the complete procedure was a game of money. Now moving on to next slide. The next case which I would like to discuss is Diamond versus Chakravarti. Now, Dr. Chakravarti was a very famous biotechnologist. He actually developed a super bug. He actually developed a bacteria, a pseudomonas bacteria. I don't know how many biotechnology or bio-related people are here, but still I'm going to explain this case, because this case changed the face of patents in the history. Okay, so now Dr. Chakravarti made a pseudomonas bacteria. Now this bacteria could digest, could metabolize hydrocarbons, 4 different hydrocarbons, and this bacteria had a potential to be used against oil spills. We all know that giant tankers of oil spill every year in sea, and there's loss of aqua life and all those things. But this bacteria was capable of digesting that oil spill completely. That means it could reduce that oil spill to a biodegradable substances. Now, at first, when Dr. Chakravarti filed for a patent, it was rejected, saying that since the bacteria is naturally occurring and since the bacteria is a living entity, it is already existing in nature, it's not made by man, it cannot be granted a patent. However, Dr. Chakravarti in turn defended his case, saying that the naturally occurring bacteria, the naturally occurring Pseudomonas bacteria, which was not capable of metabolizing any hydrocarbon, had only one plasmid in it. But the bacteria that Dr. Chakravarti made had four plasmids in it. That means, and one was naturally occurring plasmid and other three were inserted plasmids. Now these three inserted plasmids were also not naturally present somewhere, that he just isolated and inserted it. He created those plasmids to metabolize hydrocarbons. So in short, Dr. Chakravarti stated that this complete bacteria, this complete Pseudomonas bacteria could not be naturally found in on earth. That could, no bacteria is capable of metabolizing four hydrocarbons. So it is a man-made product. Now Dr. Chakravarti got a patent grant on his product, and from then onwards patents were available for living organisms as well. The condition was those living organisms, those living microorganisms should be man-made, should be distinguishable from what is already existing in nature. So now this Diamond versus Chakravarti was a very interesting case because it changed the face of patents. Now let's move on to the next slide. The next slide is trademarks. A trademark, we all know, as the name suggests, trademark is a type of intellectual property basically that consists of a recognizable sign. Let's say I have, I'm telling you about a sign that there's a blue bird on the logo. You'll immediately recognize that the logo belongs to Twitter. If I'll say F is written in blue color, you'll immediately recognize that the logo is from Facebook. Just like that, if I say ki there's a bitten apple, you'll immediately recognize this trademark or this logo is from Apple company. So you are able to recognize that sign or that design, and you are able to identify the company or the business associated with it. That means it's a trademark. Now trademark can be any word or a symbol. Let's say it could be FedEx is a trademark. Okay, it could be a symbol, it could be a bitten apple, it could be a configuration of colors. Let's say Red Bull just got its no, not Red Bull, Tiffany blue. Tiffany is a brand for jewelry and it got blue color as its trademark so that nobody else can use it. It could be any device, it could be any combination of all those things that could actually represent the business, or that is recognizable sign that identifies any product or services. Let's move on to next slide. Uh, these are few examples of trademark. You can, even if the name is not written, even if just the sign is mentioned, I'm sure you are able to recognize the business or the trade associated with it. The first logo is of Pepsi, very clear. We are being able to recognize this logo from our childhood. The bitten apple is from Apple company. UPS is from a UPS company. Amazon, A to Z with a smile. Shell, FedEx, McDonald's, very popular logo. McDonald's is very popular with creating their logo as sometimes as M and sometimes as other things. Adidas, three steps of Adidas, which is quite popular. Now let's move on to next slide. Now trademark infringement. Now you can all see how a copy of these trademarks has been made. Like Puma is a very famous brand. There was a company which was launched as Kuma with a bear. Now it's almost similar. A person who doesn't know what a Puma logo looks like, or the person who is not very familiar with Puma logo, could be confused. Now Starbucks coffee, very popular brand of coffee, and you can see how both the marks, Star Priya coffee and Starbucks coffee, both are similar in nature. They have the same green color, and in the middle there's a girl, there's a mermaid girl in that That is also a trademark infringement. With Adidas, you can see that 3 strips. Now, this League is a part of Forever 21 brand. Now, League copied these 3 strips on their clothing as well. Now, Adidas filed an infringement suit against Forever 21 so that they could stop them, and actually they did. Now Forever 21 had to pay such an hefty amount for infringing Adidas trademark that the company went bankrupt, that the company was completely destroyed. Now Paytm versus PayPal, now this case is still pending. PayPal allegedly said that Paytm has copied the color combination, the blue color combination, that dark blue and light blue color combination, and PayPal was launched first and Paytm was launched later, and Paytm has confused the consumers for using PayPal. Now let's move on to the next slide. I'll be discussing one case for trademark infringement in the next slide. That is Starbucks versus Sardar Baksh. Now, if you'll say these two names, Starbucks, Sardar Baksh, now you'll see how similar they sound. Now, Sardar Baksh has opened 5 coffee shops in Delhi. Now, they were accused of copying a similar name. Now, the name sounded that way. The name was similar, and the logo was also similar to a US global Starbucks coffee chain. Now, Starbucks registered their trademark in which they had a logo in which there was a crown maiden. Now, Starbucks Coffee said that Sardar is a Hindi word that means commander, and Baksh means pardon, to forgive somebody. So that they are not infringing anybody. But however, when the case was decided, when lawsuit was decided, Sardar Baksh was asked to change their name because it almost sounded like Starbucks. Starbucks. Okay, so Sardar Baksh changed its name to Sardar G Baksh so that it could sound in a different way. And the logo was also changed. The logo was changed to a more of a black color, and same like there was a mermaid in the center with a crown, and there was a man in the center with a cap or a pug on his head, turban on his head. Now this was asked to change to a completely different logo. Now Sardar Baksh had to change this logo as well as their name because they were infringing the logo. The logo was quite similar to the already registered logo of Starbucks coffee. Next topic I would like to discuss is industrial designs. Now, industrial designs is a process of design which are applied to a product that are manufactured through mass production. Now, a key characteristic of that designs is manufacture. It could not, let's say I have put a photo, or I have used an image of a watch. Now this watch will show you time. However, if you'll see the design, if you'll see the overall 3D structure, overall 3D shape of the watch, you'll find it very different. Now, Fitbit also tells you time as well as your steps. Now, Casio G-Shock also tells you time as well as a shape. But both the products are very different if you'll see the shape and configuration. If you'll see the pattern and color of the product, basically the aesthetic value, basically the creativity of shape or configuration are included in industrial design. Now, the creative act of determining, now the creativity of determining and defining the form of the product is basically a physical act, is basically a physical art in which you are not changing the complete idea or the utility of the product, but you are just changing the design of the product. So that are covered under industrial design. Let's say I have a phone and the shape of that phone is complete square. Okay, the basic purpose of that phone won't change. The basic utility of that phone won't change. It would stay the same it would still be used for calling, it would still be used for texting, but the shape, the design of that product has changed. So that comes under industrial design. Now in this slide, you all can see various articles whose shape were creatively designed. Now these industrial designs are also protected. Let's see, the first image is of fork and knife and basically a cutlery, but you could see how differently those are designed. The second image is of a chair. Now the chair obviously is used for sitting purposes, but see how differently and how aesthetically it is designed. The second image likewise is a watch. Fourth is of a shelf. Fifth is of a table and a chair, a dining table. And sixth is of bowls, bowls which are used for eating. Now, see how differently they are designed, how differently they are manufactured, how differently they stand from already existing designs. Now, these all things, the aesthetic appeal, the 3D structure, the creativity of the product are covered under industrial design, are protected under industrial design. Now, the next topic I would like to discuss is semiconductor integrated circuits. Now, we all know that a semiconductor wafer has many resistors, capacitors, transistors fabricated on them. Now, these resistors, capacitors, transistors, all things fabricated have their own landscape, have their own different functions, and they decide the function of the device, or they decide the function of the machine in which they are used. So the whole analogy or the whole uh, function of a design may depend on that semiconductor integrated circuit layout. Now these semiconductors are protected under Semiconductor Integrated Circuit Layout Design Act. Now they may function as an amplifier. The same circuit can function as an amplifier. It can, with few minor changes, it can work as a timer, it can also work as a microprocessor, it can also work in phones, it also works in laptops, etc. So there are various functions which can be fulfilled. Now these, the landscape, the whole formation, the whole structure of these semiconductor integrated circuits are also protected. Now there are few requirements which are to be fulfilled for registering or for protecting these IC circuits. Now the first requirement is that it should be original. Now the first requirement is somewhat similar to that of patent, that it should be original. In patent it was like it should be new. The layout should be inherently distinctive. That means it should be different from the layouts which are already registered. There might be an IC circuit that has been registered for a phone, and you want to register an IC circuit, let's say for a washing machine, or let's say for a mixer grinder. Now that IC circuit should be different from the pre-existing one, and that IC circuit should not have been commercially exploited. That means it should not have been used in any of the product up until your date of filing. Now the next topic I would like to cover is geographical indications. Now what are geographical indications? These are I'm sorry. Okay. Now these are basically, as the name suggests, geographical indication. These are indications or marks that represent a particular location on the globe. Let's say if I'll say Nagpur oranges, let's say I'll say Agra Petha, or let's say I say Bengali Rashgulla. Now a geographical location comes to your mind. Let's say I'll say Basmati chawal, है ना, basmati rice, it will, the immediately you will see India or Pakistan, it's made there. Or you'll start thinking about it's either made in Haryana or in Punjab or in Uttar Pradesh. It's an agriculture good, so it's either cultivated in these states. So any mark or any indication or any naturally occurring good or manufactured good that is used to identify a location is known as geographical indication. Now, these goods have a capability, or they have a special quality or reputation of that particular space. or a particular region, let's say I say Kashmiri saffron, now you'll immediately rely on that product. You'll immediately start thinking that if it's from Kashmir, it will be a good product, it will be a genuine product. Now that reputation of the place is attached to that product. Now there's a case I would like to discuss of turmeric patent. Now everybody knows turmeric can be is a tropical herb, very commonly used in India. We use it in our food, we use it with milk. Now it's a blood purifier, it's used for treating cold. It is an antiparasitic and it behaves like that because it has a certain compound, it has a certain um, uh, essence, or it has a certain metabolite that works as an antibacterial. So in India it is very widely used, very commonly used. So in 1995, US awarded a patent on turmeric to University of Mississippi. Now the claimed subject matter was the use of turmeric and its compounds. So they got a patent on turmeric that nobody else can use turmeric without their consent on the use of turmeric powder. Now, that turmeric powder is commonly used in India for both oral healing and for wound healing. Now, CSIR objected to the patent granted and provided various documents for the evidence of prior art. That turmeric is being used in India since a very long time. Now, it has been ages. Our grandfathers and foregrandfathers have been using turmeric. So there are documents. There are documents for those specific uses, though it's a well-known fact in India now, but it still was a Herculean task to revoke that patent. Now, after an extensive research and 32 references, like 32 references in all Sanskrit, Urdu, as well as Hindi, the patent USPTO finally revoked the patent against turmeric. So that nobody can hold a patent against traditional knowledge or geographical knowledge. Okay. The next thing I would like to discuss is trade secrets. Now, the name suggests trade secret. Okay. Now, something, a secret, a confidential information that is related to your business, that is related to your trade, that is related to your company, it is categorized as trade secret. Now it could be any formula, it could be any practice, it could be a process, it could be any instrument or pattern that has an economic value for you. That means if that secret is not well protected, it will give your business, it will give an economic value to the other person. That means, let's say an example of Coca-Cola. We all know that there is a rumor or a fact going around that only two people in this world know the actual formula of Coca-Cola. Okay, and those two people at a time are not allowed to travel together. Now it is a trade secret. Nobody knows what that formula is. Nobody knows who those two persons are and why they are not allowed to travel together. So it's a trade secret. It's a well protected secret. Now any information any information that gives you a competitive edge over your rivals, any information that gives you an economic benefit, an economic value, and you make various serious efforts to protect that information, those informations are considered as trade secret or confidential informations. Now, there are few secrets which are well kept, which are very well defined, which are very well kept. One of them is Coca-Cola's ingredient, Listerine's original formula. I read a case about Listerine original formula in which it was like that the formula of Listerine was open, was actually disclosed. However, the company which bought Listerine's original formula from a family are still paying royalty to that family because the company was not able to keep it as a secret. However, still Listerine's original formula is a secret. Now we all, a very popular brand KFC, now we all love the chicken. The 11 herb combination is still a secret. Maggie's magic masala, New York's bestseller list, Google's search algorithm. Though many people claim that Google search algorithm is not a trade secret, they can figure it out very easily. But until and unless company Google accepts that this is their algorithm, this is actually has been disclosed, it is regarded as trade secret. Now, the next topic is copyrights. This is one of my very favorite topics because copyright is actually not one right. It is a bundle of right. It gives various rights to the author, which are given automatically to the creator of original work as the work is created. Okay. In other words, I should say that it is a legal right which is used to describe various rights that a creator has over their literary as well as artistic work. As the name suggests, copyright, a right to copy. Now these rights or these registrations are given to literary work, artistic work, various computer programs, databases, paintings, books, etc. Anything that is related to literature, art, music is given copyright. The main objective of copyright is to motivate and reward the creators for creating their work and making it a public. We don't we are only charged for the cost of book. We are not charged for the cost that a person or the efforts which a person has put for making or writing that book. We are only charged for listening or not pirating a music. We are not charged for efforts put by a musician for that particular lyrics or song. So the creative work protected under theft, protected against the theft, and the benefits are received by the author. It is copyright. Now we all know a very famous case that was filed by Chetan Bhagat against the producers and directors of Three Idiots movie. I'm sure many of you would have seen that movie and many of you would have read the book. I have read the book as well as I have seen the movie. So on a personal level, I could decide that whether it was infringing or not. Even the dialogues, even certain dialogues of the book were found in that movie, and Chetan Bhagat was not given a due credit for his own story, for his story. So everything was not well. So a patent case was filed, and case was filed, and Chetan Bhagat actually won that case because there were many points that were infringing his copyright in that movie. Now let's move on to next slide. Protection of idea. Now, um um, this movie Gold and the movie Chak De India were based on the same concept. The concept was that the whole team needs to play together to win a game. If you are not playing together, you are actually giving the other person an opportunity to win. If you fail to plan, you plan to fail. This was the crux of the movie. However, no case was filed against the two of them because the concept was same. However, the story was completely different. The same case is with the game Othello and um, and a Shakespeare's novel, Hamlet. So Othello game was completely based on Hamlet. So there was no case that is filed against Othello as well as Hamlet. Now, plant variety rights. Now, um, various varieties are generated by farmers or breeders. Now these breeders don't actually use biotechnology tools, or they don't actually use various tools. They breed the material, they cross the material and generate a new variety. Now if we are working under a research, if we are working with agriculture, if we are working with plant varieties, it is considered that a breeder should have exclusive right over the propagating material. That means if I have a new plant variety, then the mode by which that plant variety can be replicated, be it by cutting, be it by leaves, be it by its roots, then I should have all the rights over that. I should be the controlling person of that material, propagating material, as well as the harvested material. Now, plant variety rights are provided to distinguishable, uniform, as well as stable varieties. The varieties which are distinguished from one another, which are uniform, which can be transferred from generation to generation, and if they're transferred from generation to generation, they should be stable in nature. It should not be like that ki one gene is expressed in the first generation and it cannot be expressed in the second generation. Now, this plant variety rights actually support high quality seeds and high performing seeds. Now, this right is actually similar to other intellectual property rights, because the person has selected which varieties to forward and which not. So it is also a form of intellectual property. Now, the next I would like to discuss is traditional knowledge. Traditional knowledge is very simple. Now, it's something related to your tradition. It's generated by humans. It is a living body of knowledge that is developed, sustained, and passed from generation to generation. Now, it could be a culturally oriented generation. Let's say in northern India we drink tea, but sorry, I'm not saying northern India. It's, let's say in Uttar Pradesh or in Haryana or in Punjab we drink tea, but if we talk about Kashmir, we drink kava. It's a sort of tea only, but it's culturally oriented. Now, traditional knowledge has their roots, has their ancient roots, which are often informally or formally transferred from one generation to another generation. Now, nobody can patent or nobody has right over their traditional knowledge. These knowledge are passed from one generation to another generation. Mm. Let's move on to next slide. What are the benefits of intellectual property? Now, since intellectual property is your own property, is something, is a work of intellect, is a work of creative mind. Now, when IP rights are given to a person, these rights basically encourage innovation. If I'm rewarded for my one invention, then I'll be encouraged, I'll be more enthusiastic to make another invention. Now, these rights are basically to reward researchers, creators, and entrepreneurs. So when an IP is generated, they support high paying jobs. It gets revenue, it derives economic growth and competitiveness. Let's say India has developed a person in India has developed a pen that could write underwater. Now, other countries would also try to gain that pen. Other countries would pay that person so that they could use that pen, underwater pen. So it's basically something that derives economic growth and competitiveness. It creates awareness among the consumers. Let's say if I'll say there's a coffee shop, Sadarbucks and Starbucks. So you'll prefer Starbucks over Sadarbucks because there's a name or reputation associated with that. It basically generates many solutions for global challenges. Like, let's take a small example of coronavirus. Before this pandemic, nobody was worried about hand sanitizer, nobody was worried about face mask, nobody was worried about a vaccination for such viruses. But as the pandemic came, as the global challenge was there, people came out with new ideas for masks, for vaccinations, for hand sanitizers. Various formulas were patented, various masks, types of masks, new inventions were also patented. So it basically gives a solution for global challenges. Now, what are the demerits of not protecting your invention? Now, if, let's say, I am a person, I made an invention and I'm not patenting it, then there might be someone else who could sooner or later would invent or would create a similar invention, or in fact a same invention, and could get it patent. Now, that person who got the invention or who reached that stage of invention after me is enjoying more is enjoying more, is enjoying monopoly over the invention which could have been mine. Okay, if you're not protecting your IP, your leaked know-hows, your leaked technical features of a product, your leaked trade secrets could be a benefit, could be an economic benefit, or could be a revenue generator for other people as well. So always protect your intellectual property before publishing it, before making it public. pub- Patent it or protect it. Now we'll see the trends of IP filings in India. From 2016, the filings of patent, trademark, as well as industrial design has been growing in India ever since. Now I have just this data of 2004 years from 2016 to 19, where you can see that patents and trademarks are all growing. People are repeatedly filing. People are protecting their invention so that they could enjoy the monopoly over their product, not the other person. Now, knowing your IP. There are 5 major stages to know your IP, to know your intellectual property. Now, the first stage is pre-IP stage, IP stage, post-IP stage, acquisition and enforcement. Now, these 5 stages are all common in any startup. If we talk about any business, it's common there. If we talk about organization, if we talk about colleges, it's common there. Now, everything starts with a pre-IP stage. Pre-IP stage has idea generation process, idea inventory, policies and contracts which are to be developed. Now the next stage is selection and administration of those ideas, how those ideas are selected, how workable ideas, how possible ideas, how potential IPs are selected. Now, post IP stage is how you will maintain your intellectual property, how you are going to commercialize your property. Now, the fourth stage is acquisition of IP. Let's say you want to grow. Your organization, your college, your startup wants to grow. Now, they'll acquire other person's IP. They'll buy stuff. They'll buy the inventions. They'll license your invention. They'll sell back your invention. Now third one is enforcement. Now you have acquired, you have maintained, you have selected, you have policies and contracts. Now you want to enforce that IP. Now you want to let your employees know how it is enforced. For those we have lectures, we have training programs and everything. Now the next is identification of IP. Now world is this world is running a lot with a high speed. Now you cannot say that one product has only one intellectual property. One single product could have multiple IP. You just need to figure out, you just need to have people who can figure it out very easily. You just need to identify it. Like for example, I have taken example of Samsung phone. Now this product have all the possible IPs, all the possible intellectual property in this, like for example patents, for copyrights, for trademarks, for designs and trade secrets as well. The technical features are protected as trade secrets. Design, the curved phone, the camera design, trademark, Samsung is a company name, it is a trademark. Patents, how the data is processed, how they have a mold screen, the startup tune of um, Samsung phone. They have copyrights over codes, over their instruction manuals as well, over their ringtones, over the video. So now this single product, you can see this single product has multiple IP on them. They have multiple intellectual property on them. So you just need to just figure out, you just need to identify what all you can take out, what all you can extract from one single product. It could be like a process, it could be the product, it could be a machine. Everything can be protected. Now, a general procedure is followed to protect an intellectual property. The first thing is application. This procedure is common from patent to your trademarks, to your copyrights, to your industrial designs as well. It's just the time duration varies accordingly. Let's say the first step is application. You file an application, then that application is examined by an examiner or an authorized person. Then that application is published, a third party or a third person may or may not oppose that application. Now that product or that invention or that intellectual property is registered. Now this is a common procedure that is being followed by um, all the for the registration of all the intellectual property. Now it's not that everybody registers IP for for revenue generation. There are companies, there are big companies, giant tech, which have registered their IP for the sake of humanity. Like they have registered their IP, then they have donated their IP for the sake of humanity. The intent behind registration was to protect them from some other company or some other person from from re-registering them, and that invention was, or that product was donated for a greater cause, for a humanity. I'll take an example of golden rice. Golden rice is a variety of rice that has high vitamin A content in them. Now, that strategy by which the strategy by which vitamin A content was increased in that rice was patented, was first protected. Then that technology, then that process was actually donated to prevent thousands and thousands of cases and night blindness, because we all know vitamin A is very important for our eyes. Same was the case with Sanofi. Sanofi has supplied very large quantities of anti-malarial compound, which was already patented by them. Sun Power Corp. They delivered solar powered lightning to replace kerosene in Philippines and many of the underdeveloped countries. Same was the case with Grit. They developed an all-terrain wheelchair, a wheelchair that can be used in plains, mountains, hilly areas, plateaus, everywhere. And this wheelchair was made from bicycle parts, from waste parts of a bicycle. So they donated this IP. They first protected this IP, and then they donated it to needy people for the sake of humanity. Now, next is a very important slide, that is revenue generation through IP. Now, IP um, is basically a venture, or basically a method that could generate huge source of revenue for you. Now there are six major types by which we can generate revenue with IP. The one is collateralization. We can collateralize with new companies. We can license our IP. We can give the other person a license to use and manufacture it. We may not give a complete license, but we can put a part of it for licensing, a part of product for licensing. We can sell our intellectual property. We can lease it back. After one lease is completed, we can lease it back. We can co-develop it with another company. We can merge with another company, or we can sign a signatory within another company to co-develop the product. We can spin out. Spin out is we can actually sell our original IP and then start working in a different domain. Let's say I am working with robots. I have sold my robot that could be used for surgeries to one company, and now as a startup I want to try something different. I want to do cosmetics. I want to make a cosmetic. I want to start a phone company. So a company can spin out also. We can scrutinize. That means we can see if any person is infringing our IP, and we can put a scrutiny over that. That also generates revenue. So next is startup and intellectual property rights. Now, if we are talking about startups, startups are basically a kindergarten. Big companies are basically board examination. So patents, or let's say intellectual property, basically levels the ground. If a startup has more patents or more intellectual property rights as compared to a big company, people will invest in startup. People will recognize the IB. People will start putting their money. People will monetize that startup in case that startup has more IP as compared to big giant companies. Now investors are likely to invest in a startup that has patents. Now this is according to a survey. This is actually a statistical data that investors actually invest more money in a startup that has some or the other IP in their name. Now IP startup, everything is not new, everything is not first and the end. Startups has been coming in India, startups are being launched, and they will be in future also. But if you'll not protect your logo, if you'll not protect your intellectual property, if you will not protect your industrial design, there are chances that your IP would be copied, would be faked, or would be uh, infringed by any other company. Now, since people are rewarded, since inventors are rewarded, hello, am I audible?
Yes, ma'am, you are audible now.
Okay, okay.
Yes.
Um, so if those startups have unique products and services, they'll people will be motivated. People will be motivated to use their products. People will be motivated to create new IP. Now I'll be ending my presentation with a company profile. Each year, new ideas are generated by startups, colleges, and universities. We all know that. Now, those ideas, those those saplings or those planted seeds or those seeds have a great potential. They have a great potential to solve a problem. They have a they have a potential to to go to a big level, to go to a startup level. Now every startup or every big company was a startup, was a seed at the first. Now the focus of our company, the focus of IPCurate is to support these entrepreneurs, these researchers, and even students on the road of idea. If a student or a faculty member or a researcher has an idea, and that idea or that IP can be protected, we help them, we support them. IPCurate also support research, as well as we also accelerate the impact of research in the society through licensing and commercialization of IPR protection. Now it's basically we want to develop an ecosystem, or a system that is very well equipped through trainings and development programs, so that that no idea is left unprotected. An idea that is worth manufacturing, or the idea which is worth solving a problem, is worth protection. And I always say that anything under the sun made by man can be protected. Now let's have an interactive session. There's a small question: can I patent my copyrighted trademark? Now, if you can really understand the problem with this question, I think our session was good enough. Now, I'll for this interactive session and for question round, I'll give the platform to my colleague, Mr. Sandesh Agarwal, who is very well versed, who is very dynamic, and a pro in his field. Sandesh, sir,
Hello, hi Bhavna. Uh,
over to you.
uh, Thanks, Bhavna. It was a nice session. I hope.
Sandesh sir, your voice isn't audible that much. Could you increase your?
Okay.
Uh,
Is it okay now?
yes, sir. Yes, sir.
All right. So, thanks, Bhavna. It was a nice session from you, and I hope everybody had enjoyed it and have make an understanding through what all IP is all about and what are the different ways by which they can protect their ideas or inventions or creations. Though there were a few queries in between, and which we tried to solve at our end, and majority of the people who may have been watching the questions being raised and the answers being put on were able to make an understanding out of it. There are
All right.
still one or two more queries which still needs answering. So one of the question is being asked by Mr. Ashok that says, "What about design of app? Anything for that?" To answer it, yes, sir, we can do so. The overall layout of the app, the way its colors are being put on, and the way it is being structured, the looks and feel of it can be protected uh, through a trade, through copyright. And how to protect intellectual property right in the innovation process? How to protect intellectual property right in the... Sir, I didn't get what Dr. Vaishali has asked, how to protect intellectual property right in the innovation process. Can you please elaborate your questions a bit more so that we can have a better answer for this? Dr. Vaishali?
Dr. Vaishali? Dr. Vaishali Badwe.
Badwaik madam. Dr. Badwaik madam. Badwaik madam. Badwaik madam. But I think
Anyways, what I could understand from this is probably it's all about the process that she may be asking for. That is there a way by which we can protect any of a process being involved in any uh, for making of a product or so. To answer that, if what she means is this only, we can protect the processes uh, depending on if those processes consist of something unique, new, and different to what we already know of, what is already being published or documented and is available for public to have an access to that, and is for some specific purpose, that is, say, to manufacture a product or a chemical or say a medicine, certain should have certain utilization for that. On those cases, that processes could be protected. Any other query by anyone?
yeah, sir, one question.
Yes.
Sir, regarding with the microbiology, there are the many strains are there available one.
Okay.
So, most of the times we are doing the certain practicals, go with the mutation type of the mechanisms are there. Can such type of the things regarding their protocols, can we copyright them? Other than the industrial point of view.
See, whatsoever your creations are, they can be protected, right? Say if you put that into a research paper, by disclosing some of your findings or the experimental work, you can put it into a research paper. So those research papers could be protected through copyright. But yes, if there is something of a special characteristic, that is, say, you developed a process for extracting those strains, and the process that you adopted has got a certain uniqueness into it when being compared to what all is already available, though you came to it through experimentation only, but those processes were not being documented anywhere, and that process was being, say, identified, or it was your findings through experimentation that yes, if you follow this process in this particular way, or these are the steps that you follow, then you can extract this strain from this particular virus, or say compound, or microbacteria, or what's of the place you are referring to. Under those scenarios, such things can be protected through filing of patents.
But we can't patent the strain.
So you can patent the strain as well. The condition is that that strain should be different enough from the pre-existing ones.
Okay, we are mutated one, madam. Definitely it is going the different characteristics one, right from the natural one. Such type of the strain we are not been patented one.
So such types of strains can be, before that, before patenting anything or before going for a patent, we do a search. We search whether any such type of patent has already been patented, or any such type of process or any such type of compound has been patented or not. First of all that, and after that, even after that, even if that strain is different, there are criterias, like let's say you have transferred a plasmid into that patent, and you have actually synthesized that plasmid by yourself. There's a scope for patent.
Yeah.
All right, sir.
Thank you, ma'am.
Thank you, sir. Thank you so much.
So any queries from the participant, please ask to our resource person without any hesitation. I requested the participants. I think no queries from the participant, ma'am.
All right, sir. So
Okay. First of all, ma'am, a big thank you for this wonderful dynamic session. You proceed one and give the best of your knowledge regarding with the very simple slides, your presentation. I'm really thankful from the organizing committee of all the 3 colleges, IQAC coordinators, as well as the NAC coordinator. Thank you very much, ma'am.
thank you, sir. Thank you so much. Thank you, Sandesh, sir. Thank you, Param. Thank you, everybody who was present here. Thank you. You all have been a very wonderful audience. Looking forward to our next sessions also.
Yeah. So within a couple of minutes, we'll start the second session. But before that, I requested Dr. Vishal Patil, sir, Vidyabharti College Seloo, IQAC member, as well as the IPR, a cell member, to give the brief introduction of today's second resource person, Honorable Agrawal, sir.
Thank you very much, Dr. Baninwar,
Over
sir.
to Patil, sir.
Yes, thank you very much, Dr. Baninwar, sir. A very good afternoon to everyone. I'm Dr. Vishal Patil, Assistant Professor in Botany, Vidyabharti College, Seloo District, Wardha. On behalf of organizing team, it's my great pleasure to introduce the second resource person of today's session, Honorable Sandesh Agrawal, sir, Manager, IPCurate Lab, Verispire Inc. Honorable Sandesh Agrawal, sir, did BTech in Mechanical from UP Technical University, DIT, and MBA in Finance from Western International University. He has about 10 years of experience in his field. Sir has trained more than 200 patents writing, professionally resulting in a vast exposure to multiple domains like mechanical, telecommunications, cloud computing, IA, big data, product design, biomedical devices, etc. etc. With this huge introduction of Honorable Sandesh Agrawal, sir, I request to start the sessions. Please, sir.
Hello, sir. Hello, everyone. And it's been a nice session by Bhavna. Just to highlight and bring in some more facts to you that you all may be involved in one or the other, say, publishing of research papers or so. And by doing so, you are giving your rights to the publication house directly without having any benefit out of it to you for those. And even if in case they are earning to say any amount of money, they don't pass it on to you. And that's what the problem with any of the research papers that you write and just submit it to the portals like say IEEE or ResearchGate or any other place wherein, or say SkyHub, any other place wheresoever you are willing to do so. While doing this exercise, people like us, or I request people to make sure that before doing so, get it protected at your end so that at a later stage, if someone else wants a copy of it, they should be paying back to what you had created or invented. And you can simply do so by getting a copyright onto it. But yes, most of the research papers that you do, all right, they have the potential for getting it secured.
आपका आवाज नहीं आ रहा है.
They can be protected through getting a patent onto it as well. So whether or not it is actually feasible for it to have a patent-based protection for that or not is something that needs to be assessed.
Sir, please start your webcam, sir.
Okay.
If you don't mind.
No, I mean, no worries, no worries. Am I visible now? Is it okay, sir?
No, it's not visible,
No,
sir.
it is not visible, sir.
Am I now?
Yeah.
Yes. Now it's
Always.
visible, sir. Yeah.
Okay. So once a research paper is being done, you need to get it cross-checked by someone to make sure that if it has any chances for getting it secured through filing of a patent as well or not. Once that is being done, it's better to get it protected through patent route instead of just a copyright, so that any company or people whosoever are willing to have an essence of what you had protected for, they had to take permissions from you, and they have to give advantage to you in some form or the other, so that you're being compensated for what you have achieved or done. And by doing so, you're not doing anything wrong, but you are actually protecting what you are creating as your work. Apart from this, if at all there is any say you want to protect your work internationally, what you need to make sure for is it's not necessarily that you're protecting in India or say foreign, but while protecting it into foreign nation, you can go directly to those foreign nations. In India, Indian government doesn't allow you to do so. And so for that, you have to first file into India, and then thereafter you can go into almost any of the country wheresoever you are willing to do so. But yes, if at all say you publish it anywhere, then you can protect anyone in foreign nation to not have a copy of patent onto that, as your publications will act as a prior art for them, and they won't be able to secure a patent or a copyright onto it, as that was what the first creation of yours and was published and was available into the public domain. So that's how these things works. But yes, your rights for it are territorial in nature. That is being restricted only to India and not anywhere else. While the other person who is trying to get a protection onto it into foreign nation, he won't be allowed to do so, because what you had already published into public domain will act as a reference, as a prior art to don't permit others to have some sort of rights onto that. So they can have things only in case when they do some additional modifications onto it, some sort of additional work onto it, then thereafter they can definitely have certain rights onto it, but not otherwise. Apart from all this, India is still trying very hard, and though it is achieving in terms of the numbers of filings that are there in India in comparison to its peers in say other parts of the world, be it say US, China, or European countries. So we need to increase our filings to as much of an extent as we can, and these rights, since are being given to the person who is filing it or the organization who is filing it. So once being filed, you can monetize your creations, your creativity, your inventions to an extent. Probably as of now, very few people have achieved those kind of success and those kind of monetary benefits in India. But yes, sooner or later, by having such knowledge and then thereafter protecting what you're creating, you can definitely have it as well. And that's how I would like to summarize the today's session. And if there's any specific query of any person who in terms of uh, protecting their IP or anything else, then you can definitely ask for it.
Sir, my one question, sir.
Yes,
So
sir.
whenever our research is there, either in
Yes,
case of our language in the English, or either the person is not having the a good background of the English one, can such type of the peoples, they cannot filing their documents in a mother tongue or the national language? Our national language is
sir.
Hindi, or and most of the forms are available in the IPA office. They're in the English. How the person will get proceed to patent their particularly the invention that will be the innovatives? Thus,
You
the best
can,
example, the best example is from the Chandrapur. The person do not having the
okay.
knowledge, and he developed the basmati rice. He do not
Right.
having the knowledge. Can such a particularly the person, their innovation process is get lackings there in the certain system?
Sir, under those scenarios wherein you want to protect it in a natural language, the way going forward will be to take services from of some, say, language translator first, and then thereafter approaching to a consulting firm like us to help you out to get your things being protected through the route whatsoever is suitable to what is your creations. Apart from that, you can yourself publish it on your own into any of a blog or somewhere, but that can only give you only bar others from getting a protection onto it, but you won't be having any sort of certain rights onto it because it's just being published and not being taken any specific rights onto it by filing it with the IP offices of India. Does that answers your query, Dr. Yogesh?
Yeah, sir. But the same, particularly the patent, if we are filing in our own languages, there should be a translator. They can translate it. Why before the?
They can do so, sir,
It
but
means we are
they're
not
not
giving
doing
the.
it as of now.
It means we are not giving the
Probably in the
respect
near
to your
future, they
our
may do
national
so.
language. The officers cannot give the respect to our official language. That's the biggest drawback of the system.
Oh, so I cannot do anything about it. Probably you had to appeal for that with the government office for that.
Yeah.
Sir?
Yes, sir.
Yeah, sir.
Hello.
Yes, Davande sir, please ask.
One question, sir. You said the patent, if I got patent in India, is it applicable to other country? Means you said that it is rights, so that my patent is available, or the impact of my patent is applicable to all the country or all over the world?
See, patents, one being filed into any country, are applicable as a reference to all the other places. And they act as a base point in order to check others' filing that yes, whether or not what others have filed are new or not. But yes, the rights that are being given to your filing are restricted to the country where you are filing. But yes, if other person tries to copy it, file it into their country, he won't be able to get a patent onto that because you were the first to do so. And for those reasons, your application will act as a reference, and no one will be able to secure a right onto it until and unless they do some sort of additional work on top of it, which is also good enough and accepts and is acceptable to their patent office.
Thank you, sir.
Okay, thank you, sir.
You're welcome, sir.
Okay, now I requested the one day, sir. Please say a few words on this occasion. As a IQAC coordinator, Arts and Science College
Yes, sir.
of Pulgaon.
Thank you, sir. On the behalf of IQACs of all the three colleges, I would like to share a few things on this occasion. Today, our resource person, respected Bhavna Singh Madam and respected Sandesh Agrawal sir, have shared their invaluable insight, experience, and expertise with us. And also Param Doshi sir has given their time and support. So on the behalf of IQCs from all three colleges, sir, we are really thankful to you, sir, for
sir.
sharing this wonderful knowledge. I'm sure today's workshop was fruitful to all the participants in order to solve their query. I once again thankful to all. Thank you, sir. Over to you, sir.
Thank you, sir. Now I requested the Honorable Principal, Dr. Sanjay Kanode, sir, Vidyabharti College, Seloo. Please say a few words on this movement. Over to Dr. Kanode, sir, Principal, Vidyabharti College, Seloo.
Sir, please wait for a couple of minutes.
Okay, okay.
हो चालेल अटॅच आहे ना
Yeah.
Audible, continue.
Yeah, over to Kanode, sir.
Hello.
Yes, sir. Yes, audible, sir.
Sorry for late.
Yeah, sir. Please give your remarks, sir.
Okay. Vidyabharti College, Seloo, New Arts College, Wardha, आणि आर्ट्स अँड सायन्स कॉलेज पुलगाव यांच्या संयुक्त विद्यमाने आज इंटेलेक्च्युअल प्रॉपर्टी ऍक्ट यावरती नॅशनल वर्कशॉप आपण आयोजित केला होता. या वर्कशॉपला उपस्थित आणि ज्यांचे आज विशेष मार्गदर्शन आपल्याला लाभलेले आहेत भावना सिंग मॅडम यांचे मी प्रथम महाविद्यालयाच्या वतीने आभार व्यक्त करतो. त्याचप्रमाणे ऑनरेबल संदेश अग्रवाल सर यांनी देखील इंटेलेक्च्युअल प्रॉपर्टी ऍक्टच्या संदर्भामध्ये जे मार्गदर्शन आपल्याला केलेले आहेत त्याबद्दल देखील मी त्यांचे महाविद्यालयाच्या वतीने आभार व्यक्त करतो. आज सर्व स्तरावरून IPR ज्याला महत्व दिले जात आहे आणि विशेष करून आपल्या एज्युकेशन सेक्टरमध्ये ज्या फॅकल्टीज आहेत त्यांनी देखील या इंटेलेक्च्युअल प्रॉपर्टीच्या संदर्भामध्ये विशेष लक्ष देऊन त्यांच्याजवळ या संदर्भातली जी काही रिसर्च आणि जे काही त्यांचं प्रॉडक्ट आहे याचे देखील त्यांना कायद्याने राईट्स प्राप्त होतात, अधिकार प्राप्त होतात. त्या अधिकारावरती त्यांनी विशेष लक्ष देऊन काही पेटेंट्स देखील आपल्या नावाने त्या ठिकाणी त्यांनी करायला पाहिजे आणि यासाठी म्हणून त्यांना उपलब्ध असलेल्या संसाधनाचा वापर इंटरनेटच्या माध्यमातून करून एक स्वतःच नावाचं एखादं पेटेंट त्या ठिकाणी असायला पाहिजे. त्या दृष्टिकोनातून महत्व आपल्याला या समजून घेण्यासाठी म्हणून आज आपण हा वर्कशॉप, नॅशनल लेवलचा वर्कशॉप तिन्ही महाविद्यालयाच्या वतीनं आयोजित केलेला आहे. या आयोजनासाठी न्यू आर्ट्स कॉलेज वर्धेचे प्राचार्य डॉक्टर आशिष ससनकर सर यांनी मोलाचे योगदान यामध्ये दिले. त्याचप्रमाणे आर्ट्स अँड सायन्स कॉलेज पुलगाव इथले प्राचार्य डॉक्टर हाडगे सर त्यांचे देखील आपल्याला मोलाचे सहकार्य या ठिकाणी लाभले. त्याचप्रमाणे विद्याभारती संस्था आणि महिला संस्था, महिला विकास संस्था वर्धा यांचे सन्माननीय अध्यक्ष डॉक्टर RG भोयर सर यांनी हे वर्कशॉप घेण्याकरता आम्हाला प्रेरित केलं. याबद्दल देखील मी त्यांचे आभार या ठिकाणी व्यक्त करतो. आणि विशेष करून जे पार्टिसिपंट्स यामध्ये सहभागी झालेले आहेत त्या सर्व पार्टिसिपंटना आवाहन करतो की हा इंटेलेक्च्युअल प्रॉपर्टी ऍक्ट त्यांनी समजून घ्यावा आणि त्यानुसार आपल्याला काही करता येईल का याचा विचार करून या गोष्टी आपल्या आयुष्यामध्ये त्यांनी करण्याची गरज आहे आणि त्यांनी ती करावी. साध्या साध्या इनोव्हेटिव्ह, साध्या आपण काही एखादा शोध लावलेला असेल तर त्या शोधाचं जरी स्वरूप लहान असलं पण त्याचा उपयोग जर समाजाला होत असेल तर त्यासाठी त्याला पिक्चराइज करणं, त्यासाठी त्याला पब्लिसिटी करणं हे आपलं काम आहे आणि ते आपण केलं पाहिजे. इंटेलेक्च्युअल प्रॉपर्टीमध्ये साधारणपणे आपण बघतोय की जुगाड तंत्रज्ञान यामध्ये आपल्या जो असलेला स्क्रॅप किंवा आपल्याकडे असलेल्या जी काही साधनं उपलब्ध असतील यामधून आपल्याला कुठल्याही प्रकारचं अशा प्रकारचं एखादं संसाधन निर्माण करता येऊ शकते की ज्याचा उपयोग हा सर्वसामान्यांना देखील त्या ठिकाणी होतो आणि त्याचा फायदा त्याला घेता येतो. कृषी क्षेत्रामध्ये असे अनेक प्रकारचे त्या ठिकाणी तंत्र आहेत की ज्याचा जरी मार्केटमध्ये साधनं उपलब्ध असतील पण आपल्याकडे असलेल्या रॉ मटेरियलच्या माध्यमातून आपल्याला काही साधनं तयार करता येतील का, अशा प्रकारचा विचार हा या क्षेत्रामध्ये काम करणाऱ्या प्राध्यापकांनी करायला पाहिजे. साध्या उंच बिल्डिंग असल्यानंतर त्या उंच इमारतीला मधमाशांचं पोळं हे सातत्याने लागत असते किंवा जे पक्षी असतात कबुतरासारखे हे त्या बिल्डिंगवर येऊन बसतात आणि ती बिल्डिंग खराब करतात. तर अशामध्येही आपल्याला काही त्याच्यावरती उपाय शोधता येतो का याचा जर आपण विचार या ठिकाणी केला तर ते आपलं एक संशोधन ठरू शकतं आणि त्याचा फायदा हा आपल्याला सगळ्यांना आणि इतरांना देखील आपल्याला देता येतो. शेतामध्ये पक्षी, जनावर, जे रानटी जनावर असतात ते आपले शेत मध्ये असलेले पीक खराब करतात. तर अशांना देखील आपल्याला काही आपल्या जो असलेल्या साधनातून बंधनं घालता येतील का, त्यांना प्रतिबंधित करता येईल का, याचा देखील विचार हा जर आपण या ठिकाणी केला तर मला असं वाटतं की आपणही एक त्या ठिकाणी त्यामध्ये निर्मिती करू शकतो. आपण एखादी वस्तू निर्माण करून त्याचा फायदा आपण समाजाला घेऊ शकतो. आज इंटरनेटच्या माध्यमातून अशा अनेक गोष्टी आपल्याला सहजपणे उपलब्ध होतात की कुठे कुठे काय काय कशा पद्धतीने तयार केलं जात असते. तर त्याचा उपयोग आपण त्या ठिकाणी करून आपण केला पाहिजे. यामध्ये आपल्या सर्वांचा तर तुमचा फायदा आहेच. ज्या फॅकल्टीने त्याचा शोध लावला त्याचा तो फायदा त्या ठिकाणी आहेच, पण सोबतच त्याचा बेनिफिट संस्थेला आणि महाविद्यालयाला देखील त्या ठिकाणी प्राप्त होतो आणि एक नावलौकिक प्राप्त होते. तर अशा प्रकारचे शोध जे आपण लावलेले असतील त्याचे पेटेंट घ्या, ते स्वतःच्या नावाने स्वतःकडे त्याचे अधिकार ठेवा आणि त्याचा उपयोग हा समाजाला करून घ्या. तुम्ही जे काही रिसर्च वर्क करता लिखाणाच्या स्वरूपामध्ये, पेपर्सच्या स्वरूपामध्ये, त्याचा देखील आपल्याला आपल्या स्वतःचा अधिकार आपल्याकडे ठेवता येतो. त्याचा कॉपी त्याची कोणी मारणार नाही, प्लॅगॅरिझम त्यामध्ये होणार नाही, याची देखील काळजी आपल्याला त्या ठिकाणी घेता येते. तर आजच्या या वर्कशॉपच्या निमित्तानं आपण सर्व एकत्र आलात. विशेष करून त्यांनी आपल्याला मार्गदर्शन केलं त्यांचे पुनश्च मी या ठिकाणी आभार व्यक्त करतो. डॉक्टर ससनकर सर, डॉक्टर हाडगे सर, बंगिनवार सर, दवंडे सर, डॉक्टर विशाल पाटील सर, त्यांनी हे संपूर्ण वर्कशॉप आयोजित करण्याकरिता टेक्निकल त्या ठिकाणी सहकार्य दिलेलं आहे. त्यांचं सगळ्यांचे देखील मी पुनश्च आभार या ठिकाणी व्यक्त करतो. आणि आज मी थोड्याफार प्रमाणात या वर्कशॉपला आपण जॉईन होऊ शकलो नाही. त्या कारणास्तव मला थोडं माझ्या कॉलेजला एक कमिटी आहे त्यामुळे मी थोडं कंटिन्युएशन मध्ये राहू शकलो नाही. तरी आपल्या सर्वांची पुनश्च माफी मागतो आणि मी या ठिकाणी थांबतो. धन्यवाद. ठीक आहे.
Thank you, sir, for your wonderful words. Before taking the last section as a vote of thanks, I have to say something. In a capacity of the NAC coordinator, a member of the IPC cell, I first of all thanks to the organizing committee who gives this a best one to arrange such type of the workshop to get the basic knowledge on their intellectual property. I thankful to our management. Every time they boosting us to arrange such type of the programs in a cluster IQAC. I really thankful to our management, President Dr. R.G. Bhoyer sir, Secretary Dr. Abhijit Verulkar sir, all the three principal, Dr. Hadge sir, Dr. Kanode sir, Dr. Sasankar sir, all the IQAC member, Professor Davande sir, Ashish Tiple sir, and a Professor Achegave sir. Behind the screen, they're doing their best job, right from the technical part to release the flyer. Really thankful to Professor Davande sir for giving the best of this flyer. On the behalf of a NAC coordinator, I thanks to our today's honorable resource person, Bhavna Singh madam, Sandesh Agrawal sir, a manager, IP curator. They sharing their valuable time and enlightening all our difficulties by interacting with answer question and answer session. Thanks to everyone. Now I will requested Professor Pethare sir to give the vote of thanks. Professor Pethare sir. Sir, humming येत आहे थोडासा.
Okay.
Yeah. Now it's good.
It is an honor for me to propose the vote of thanks for this national webinar on intellectual property awareness. So I would like to thank speaker Sandesh Agrawal sir and
Pethare sir, please check your voice. It's an humming.
हे पेपर आहे इथे फक्त हे लावून देते का आणि त्याच्यावर बुकवर इथे साइन करतो.
Pethare sir. Please unmute, sir.
Hello.
Yeah. Now.
Is it okay?
Yeah.
So it is an honor for me to propose the vote of thanks of this national webinar. I would like to thank our guest, Honorable Bhavna Singh Madam, for enlightening us with their knowledge and expertise in intellectual. Today's online workshop was full of various interesting things too. Deep insight into the topic and reveal many interesting facts. So, in biotechnology, the point where Bhavna Singh Madam aware told us the various examples from biotechnology was really informative, Madam. Pretty sure precious information that Honorable Sandesh Agrawal gave us to help to secure our invention. At the same time, I'm also thankful to Dr. Organised, Principal New Arts, Commerce and Science College, Wardha, Dr. Sanjay Kanod, Principal Vidyabharti College, Seloo, and Dr. Vilas Hadge, sir, Principal Arts and Commerce College, Pulgaon, guidance and supports for making this event successful. I'm also thankful to all the IQAC coordinators for making the event successful. Thankful to Dr. Banginwar, Dr. Ashok Davande, Dr. Ashish Tiple, Dr. Patil, and Dr. Pramod Ajigave. I'm also thankful to all the delegate participants and for their enthusiastic participation. And with the permission of Chief Organizer, conclude here. The program is over. Thank you. Thank you very much.
Thank you, sir. Now, with this permission, the program is get over. Already, the feedback link is put into the chat box. Please hit the feedback link. All the participants are requested. Please check the chat box. Already the feedback link is there. Fill this feedback. You get the participation certificate very soon on your email. So thank you.
Thank you, sir.
Okay, shall I end the session?
Okay, sir.
Okay, thank you.
Thank you, sir.
Thanks, everyone.
Thank you for allowing us to participate in the conference.
It's our pleasure, sir.
Yes.
So definitely next time we will again meet on the different phase.
Yes, sir. Definitely, sir.
Yeah. Thank you, sir.
Thank you very much, sir.